criminal defense attorney Ryan Pacyga with ArrestedMN.com, and I am a federal criminal defense lawyer. I practice coast to coast, but I'm based here in the Minneapolis-St. Paul metropolitan area. And I like educating people and being helpful to them about the criminal law and procedure and how to get through a case and everything like that. It's good to be helpful for people. Today, I thought one thing that would help is to educate people a little bit about the big differences between a federal criminal case and a state criminal case, all right? So how do you know if a case is federal? Well, the most obvious way is if you look at the indictment or the charge and it says United States of America versus you or your friend or whoever the defendant is, right? Instead of like the people versus blank or state of Minnesota or state of California versus blank, okay? That's one way you know it's a federal case. Another way that often, unfortunately, people find out is that they're arrested by the U.S. Marshals or other federal agents. There's been what's called a sealed indictment, which is the charges, and now there's been an order to go arrest the people, and they get rounded up and they're brought pretty quickly before a magistrate judge in the federal court where the proceedings begin, okay? Most people are indicted. That's how most people are charged. We're going to talk about what's most common, all right? So one of the first big differences between federal and state court is that there's no money bail. A lot of times in other states, you can put up a money bond or cash bail or get a bond agent and things like that. That's not how it works in federal court. What happens is that the court first has to determine if the government, who are the prosecutors, are asking for detention in a case, okay? And in many cases, they will ask for detention, but not always. If they're asking for detention, usually the defendant is then held in a local jail or a jail where the feds hold people, and every county is different that way. And then eventually you get a detention hearing, usually 2-3 days after, sometimes 4 or 5 if it's a weekend situation and something like that. And you can have a battle in a detention hearing about whether any conditions that the judge could impose other than holding you in jail are reasonable under the circumstances and are less restrictive than just keeping you in jail the whole time. Those conditions sometimes mean always like surrender your passport. Sometimes you can get to go home and be on pretrial release and still go to work and those things, but you got to check in with a PO here and there or some other things. Other times it's more than that. You're in a halfway house, or you're on a GPS ankle monitor and things like that, so they know your movements everywhere, and you might even be grounded during certain hours that you're on that GPS other than going to work or meeting with your lawyer or things like that. So that's one of the big differences, no cash bail or bond with a bond agent, if you will. Second, you generally don't get as much evidence, which is called discovery in a case, as you do in state court cases. That's not always the case. Sometimes we get massive amounts of evidence, especially like in a white-collar case, sometimes terabytes of information. But generally speaking, you get a little more discovery if it's a state court case than you do in a federal case, and the feds don't quite have to give as much over to you, and sometimes they get to give you things much later in the game in terms of the procedure of your case, later, almost right before trial, some sorts of evidence that you would get much earlier if it was a state criminal case. And so it can be a little bit of trial by ambush to a degree, and that can really make it hard to defend a case when you're getting hit with usually bad information right before a trial that wasn't out there before. Third, the timelines are usually quicker, a lot quicker. Now, of course, in state court, sometimes you can demand a speedy trial. You've got some speedy trial rights in federal court as well. But just the general timelines, even if you're not in detention, are more compact. They're quicker from the time you're arrested until you're given a trial date often, and when motions are due and when discovery is due and those things. A lot quicker generally in federal court than you may be used to in a state court case. So that's a big one. Fourth, the sentencing guidelines and mandatory minimums are usually higher than in state court. Federal criminal sentencing guidelines are harsh for the most part, very high sentences, and they're talking about in ranges of months, okay? Much higher usually than a state court offense that's on the same level of an offense. Not always. There are some exceptions, but often the federal sentences are much higher. And there are more mandatory minimums in federal court, and some of those are 5 years. Some often are 10 years, and there can be even 20-year and some life situations going on. So the federal sentences can get quite harsh. And the mandatory minimums often mean more as a mandatory minimum than some state mandatory minimums do, where there's other ways to get around them. I'm not saying there are no ways to get out and around some mandatory minimums in certain situations in federal court. There are. That's not a topic of this video, but there are some situations where there are ways out from under mandatory minimums, but not always, and sometimes not, unfortunately, not often, and they can be quite harsh. Fifth, this is a big shocker. Besides the amount of time people are looking at if they're asked to plead guilty or if they're going to trial, and if they lose what they're looking at, a lot of people are shocked at the amount of time they're facing in a federal case. And then the other thing they're shocked about is that there's not a lot of certainty in sentencing in federal court. In many state court cases across the nation, there is some more sentencing if you plead guilty as to what you've come to an agreement with the prosecution. For example, here in Minnesota, right, a lot of plea agreements in state court, if someone chooses to plead, might be like you agree to get 14 months in prison, or you agree to do 48 months, or just an agreement with how long, or you agree to 30 days of jail or something. In federal court, it usually doesn't work that way unless there's a mandatory minimum. What can get harsh on those is, let's say the guidelines. So we use this grid for guidelines, and the vertical axis is basically the severity level, or all your points that add up, and then the offense level. And then the horizontal axis is your criminal history. The more criminal history you've got, the worse a sentence gets in any given severity level, okay? But at any rate, once you're within this range, let's pretend there's not a mandatory minimum, for example, and I'm just going to make up numbers, all right? Let's say the range is 85 to 100 months in the sentencing guideline range in that particular box. A judge will usually look at you in a plea hearing and say, listen, I understand what you've come to in the plea agreement, but you understand that that's an agreement between you and the government, which means the prosecution, and the judge isn't bound by that. And as they sit there that day in your plea hearing, they have no idea how they're going to sentence you, is what they'll usually tell you. And that's because they haven't read your whole background in a pre-sentence report yet, heard arguments from the lawyers and those sorts of things. But an honest criminal defense lawyer that does a lot of federal work, we have to look at our clients and say, unless there's a mandatory minimum, all we can do is try to guess what your sentence may be. It could be anywhere in this range. It could certainly be lower, and oftentimes we do ask for variances or departures, which are much lower than these harsh federal guidelines. But you're not locked in with the same certainty as you might be used to in state court, where if you plead guilty, you're going to get 36 months in prison, or 60 days in jail, or 60 months in prison, or whatever. There's just not that level of certainty. Now, if there's a mandatory minimum and you can't get out from the mandatory minimum, then there's some certainty, at least with respect to you're going to get at least that amount of time, which can often be harsh as well, because get this. Let's say that guideline range I'm talking about, you've done all the math on the severity of the crime, the criminal history, and the sentencing guidelines, let's say, recommend a sentence of, I'm going to make up numbers again, 70 to 84 months. That's what the sentencing guidelines recommend in that range. But you've got a 10-year mandatory minimum on the case, and you can't get out from under it. That means that although the guidelines recommend a range of something lower than the 120 months, the judge must give you 120 months, no matter what the guidelines recommend, unless you get one of the ways out to get out from under mandatory minimums, which I should probably make another video about to be more helpful. So I'll think about that, okay? But anyway, I wanted to educate you about that. The bottom line is that federal cases are much different than state criminal cases. They're generally harder in a way. The government doesn't have to give you as much. The timeline, their investigations have been going on longer often. They're stricter on the lawyers. They're stricter on the defendants. They move faster. The law is more severe in terms of the sentences people are facing, and the law is often more complicated as well, especially these sentencing guidelines calculations and things like that. And it's for that reason, I think, that many criminal defense lawyers don't even do federal case. They won't touch it. They'll refer it to another lawyer who does a lot of federal criminal defense cases. And the best advice I can give you is to get a lawyer that has a lot of experience defending a federal case. If you or a loved one are facing a federal case, get a lawyer that's got a lot of experience in federal cases, because they are unique. There's a lot of surprises in them if people don't know what to watch for and haven't done federal cases much before. And you've got it all riding on the line if you're indicted federally. If you found this video helpful, will you please let me know? Maybe you could like the video, subscribe to my channel, even share it with someone you think it might be helpful for. I do enjoy educating people with videos and helping out. My name is Ryan Pacyga. I'm a criminal defense lawyer based here in Minneapolis, St. Paul area. I do a lot of federal criminal cases and state cases, and I do take cases around the nation. You can find me at arrestedmn, like Minnesota.com, or call me at 612-339-5844. Go make it a great day.